I think this is one of the best ones you're gonna hear with 2-star guest lecturers. And we want to talk about all things legal. So anything that's involving setting up your company, setting up the relationship between co-founders, setting up the relationship with investors, and also how do you go about registering your company, setting it up. All of those things are important. Also, the transfer of your IP. You're all research students right now, mostly, correct me if I'm wrong, Mike, but the university owns the intellectual property. That's right. And how do you then get it out of the university and get it into your company without too many onerous and draconian hooks, which universities are famous for? And lastly, we want to look at the entire legal structure of your company. As Colin said to me 10 minutes ago, we're engineers. We don't know how to set up companies. We don't know things like stock options and preferred shares and all of those other things. And trust me, most people don't, even people who are running companies. So, as we always start with some relevant Ashokisms, you know that? Life lessons that are relevant. So the first thing I say to people, young students who are trying to take companies with a lot of technologies, don't build walls around your technology, build moats. That's sort of a concept of saying, you know, your legal strategy is as important as your technical strategy over time, because that's what helps you survive, even flourish. And the best example I can give is Compaq Computer. Even though they were going to break IBM's monopoly when they opened, they also realized that the legal strategy had to be so clean that IBM could not challenge them and bring them down, like IBM had done in the past to other wannabe companies. Does that make sense to you? And then fortunes, this is something, fortunes were not built by inventing, they were built by controlling the legal right to the inventions. If you didn't have the legal right to the invention, it didn't matter what you invented. So remember that too. One more, your training teaches you to share knowledge. That's what you do between partners, between fellow students. And entrepreneurship requires you to protect that knowledge. They're paradoxical requirements. So think about that too. And finally, they are not bureaucratic necessities, legal and IP. They're absolutely fundamentally essential to create competitive advantage. And they're disguised as very onerous paperwork, but that's what these two gentlemen will help you through. Today's agenda, we're going to go through essentially 15 points, and I'm going to let it come to why legal and IP matters. It protects your innovation. It increases the value of your innovation in the company you're trying to build. It allows you to attract investors and enables you to create partnerships. Without the protection of your intellectual property, none of this is possible, or it's much more difficult. So we have 2-star presenters today. Lee Davis, who we start with, partners at Hunton Andrews Kurth, one of the premier law firms of Houston. So Lee, thanks so much for being here. This one.
All right. Well, good morning, everyone, and happy to be here. And thank you to Ashok for asking us to come speak with you. So I'm a partner at Hunton Andrews Kurth. I'm in our corporate group. I do mergers and acquisitions, venture capital, and capital markets. And we've worked with Goose Capital for a number of years now, helping with their investments in startups. We also represent a lot of startups, so we see we see the legal issues from both sides in terms of being on the company side and negotiating opposite of investors, or being on the investor side and as they invest in companies. So, today what I want to cover is kind of some high level. I think the slides are going to be available.
Yes, they're all good.
There's
every lecture is available at this one too. Great. And I think some of the material in this lecture, the most important, other than the one on the financial modeling, this is the other one that's really important.
Yeah. so there's more detail in the slides than, I don't just want to read off the slides. There's more detail in the slides than what I'll probably cover today. I want to hit the high points, give you things to think about. And then as you look through the slides, you'll have some additional material to consider. But really it's, thinking about, setting up your entity, considerations to think about, vis-a-vis, co-founders, equity allocations, how you set up an entity, how you structure, thinking about your equity, how you think about bringing on employees and equity that you're issuing to them, and also assets, which is primarily intellectual property, thinking about how you either control that, own that, license that. And Greg will talk more about how you protect IP. But the general idea is that you should be thinking about any intellectual property that the company is developing, the company should own. That needs to be well documented. So the first thing is the form of entity. When you think about setting up an entity, there are generally two types that people are familiar with. There's limited liability companies, LLCs, and there's corporations. For the most part, tech companies are corporations. They're C corporations. There are sometimes reasons to do an LLC, but I think for the most part, they are corporations. So we'll just kind of assume that we're talking about corporations today. Generally, you're talking about Delaware. You probably hear about, what state should you incorporate in? And generally, we use Delaware as kind of just a well-trodden state that investors are used to seeing. It's got very well-established business law, business courts that have dealt with these issues. So it's generally a Delaware corporation. And in thinking about setting it up, generally what we do is we form the corporation in Delaware. We'll authorize a number of shares of common stock, one class of stock. And that's what's issued to the founders. You'll have bylaws, you'll have a board of directors, which is generally just the founders themselves. And it's pretty straightforward. You'll have officers, CEO, treasurer, just kind of your standard officer positions that you can take corporate action. The initial equity is something to give some careful thought to. If you're a solo founder, just by yourself, it's pretty straightforward. You're going to be the initial, 100% owner of your entity. If you have co-founders, you really want to be thoughtful about what are the splits as between the co-founders. If you're a team of two or a team of three, you may think, well, if we're a team of two, then it should be 50-50. Maybe it should be, but maybe it shouldn't be. Because ultimately, you're going to have to explain and have a good, well thought out reason for why does X own 50% of the company and why does Y own 50% of the company. If X is doing 80% of the work and Y is doing 20%, then we're going to get asked about that. The last thing investors want to see is a co-founder that has a bunch of equity in the company but isn't doing a whole lot for it. And we'll talk about vesting in a little bit. Vesting is very important in terms of how you earn your equity in your company. And if you end up leaving the company, or if you end up not earning your equity, how does it get forfeited back to the company so that the company can use it and divert it to someone who is going to build value in the company? So one important thing to think about is clear record keeping for equity issuances. So you should have any equity issuance that you make, whether it's to your founders, to your co-founders, to employees, to a consultant that's doing work for you. It has to be documented in writing. When you get way down the road and you're doing like a Series B or a Series C, and you start maybe looking at audited financials, the auditors are going to go back and look, and they're going to need to see and tie out every equity issuance that you've made. And so the last thing you want is to have someone on your cap table that has equity in your company that you don't have it documented somewhere. And we run across this all the time where, oh, I promised, so-and-so 1% of the company, and it was never documented. It wasn't even written on a napkin, so to speak. which is also not a good way to do it. But the last thing you can run across is somebody on your cap table that there's not a written agreement for, or also someone who's not on your cap table who then pops up and says, oh, wait, I'm supposed to have 1% of the company. The founder promised me that. Why am I not showing up? So just very important to be thinking about from the very beginning, when you come and you form your entity, let's say you're co-founders, 2 co-founders, 3 co-founders, your equity that's issued to you, that's documented. And then as you start to bring on employees, start working with consultants, maybe you have a board of advisors that you want to issue some equity to, every single one of those equity issuances will be documented. That should be. So no napkin promises and definitely no oral promises. So generally speaking, not to get down into the weeds too much, but generally speaking, like I said, we will authorize one class of stock in the corporation called common stock. And that's generally what founders, employees, consultants get. It's called common stock. We will also put in place typically an equity incentive plan. So how do you issue stock options or equity to employees, consultants, advisors? Generally, there's a plan that kind of sets out the different types of equity that you can issue. And then you've got a form of stock option agreement, form of restricted stock agreement, and you've got a pool of reserve, say 10%, 15, 20%, a pool of stock reserve that you can just issue out of to employees. And we have these are standard documents, standard plans that we set up at the very beginning so that it's easy to onboard, because if you're quickly hiring employees, you need to be able to quickly get these offers out. Just going back to equal ownership sounds great, but it could create problems. One is, you have to be able to explain why everyone has the equity they do in your company. The second thing is, and it's not necessarily a bad thing, but if it's 50-50, then majority requires both of you to consent to something. You can run into deadlock issues, and that may be fine. We've set up plenty of entities that have 2 co-founders. They say they're 50-50. They're equally working in the business, so it makes sense and it's justifiable. But we just advise them that, look, anything that comes to you two, you're both going to have to agree on it. So something to think about. Equity controls. So transfer restrictions, but mainly vesting is what I want to talk about. So when you are issued, especially in any type of co-founder situation, when you're issued equity, you do want to have the co-founders each subject their equity to vesting. And vesting is just the idea that typically it's time-based. You see it all over the place, but you often hear about a 4-year vesting schedule. You earn 25% of it after the first year, and then it vests monthly after that, so that at the end of 4 years, if the co-founder, the employee is still working in the company, they fully earn their equity. If they leave before then, they forfeit a portion of unvested back to the company. And the reason for doing that is, what you don't want to have to explain to investors is a big chunk of equity on your cap table owned by a person that's no longer with the company. The idea is keeping the equity in your company for those people who are working in the company and building value in the company. And we've seen, plenty of times when founders have come to us, they've set up their entity, they didn't want to do vesting, or they haven't done vesting, and co-founder leaves. And, co-founder divorce happens very often, very often. You have 2 co-founders come to you, everything's great, they're excited to get going, they work for a while, and then something comes up, something happens, and there's a falling out, one of them leaves, and their shares weren't subject to vesting. The company doesn't have a repurchase right, and so what do? You can't force them to sell their equity. You have to negotiate with them or figure out a way to try to get that equity back, and if you can't, then it's just there and you have to deal with it. So very important to think about vesting, subjecting co-founder vesting, employees, consultants to some sort of vesting schedule so that you can keep control of the equity in your company.
Question. We went through a lot of steps here saying, we need to do this, we need to do that. So when do you do this? Is it on day one when you form the company, or
At the very beginning. So the steps to be thinking, if you are a founder or a co-founder, you would go to an attorney and say, we need to form the entity. The very first things you would do would be, you put your bylaws in place, you have your board, and then the equity issuances to the co-founders would be done at that time as well. So,
And it is all done by the attorney.
Correct.
In consultation with the founders.
Correct. Yep. And so you would have your equity issued to you. You're the only founder. If you have a co-founder, you would be the first two people to show up on your cap table. And that equity would, like I said, we would typically advise that it be subject to vesting, which protects, like I said, not only the company, but each of you as co-founders if the other decides to go to something else.
So as time goes by, let's say a year passes by, you need more capital. You said you can set aside certain amount for employees or growth for the founders. So do you plan all of this right in the beginning, or you do it as you go by?
Yeah, great question. So you set it up initially very simply where you have your equity issued to you and maybe you set up 10 to 20% of your shares to go to employees. But as you start thinking about raising money, as you raise money, basically it's generally going to get torn up and redone. It's always evolving, it's always changing. So your equity doesn't change, but you start building on top of that. And I'll get to a portion here where we talk about kind of fundraising and the type of equity that investors will get in the company. But it's always evolving. You're always kind of re-looking at where you are and what you need to add, you need to increase your options.
Thank you.
Okay, so we talked about initial equity. I think I've covered some of this, again, issuances to employees, contractors. I mean, be thoughtful about the size of equity award you give to employees or to contractors. There are kind of go by market terms out there for, how much a CTO should give versus, someone that's, in a lesser role. You're just going to want to be very thoughtful about the amount of equity, because equity is your most valuable, asset to give out to employees and consultants. So be thoughtful about it. You don't just want to be, giving equity out in a way that doesn't fit the business plan and doesn't drive value to your company. That's what you should always be thinking about. And again, vesting, forfeiture, the same thing applies for employees and consultants. Their equity should be subject to vesting, so that if they do some of the work and earn some of their equity, but not all of it, what they didn't earn goes back to the company. I'll just touch on IP and assets. And this is in terms of, again, setting up your entity, exercising dominion over your assets and making sure that's well documented. The same way that you want to document your equity issuances, you want to make sure that it is documented, what the company owns, that the company owns or has the rights to intellectual property that it's developing and creating, whether or not it's patentable. And Greg will talk more about the different ways to protect intellectual property, but regardless of how you might choose to protect it, or whether it's patentable or not patentable, you're generating intellectual property related to whatever product you're working on. And it needs to be very clear and well documented that the company owns that. So a document that the founders, for example, and any employee will sign is an invention assignment agreement that says that anything that employee creates while they're working at the company is owned by the company automatically. And so then you make sure that you have all of the intellectual property that's owned by the company, and then you would work with someone like Greg to determine how should we best protect that. Is it patentable, and is patent protection the best way to go about it? Or is this a trade secret, and how do we protect it from a trade secret standpoint? Copyright to a certain extent related to software, and then trademarks in terms of if you're a brand heavy type company, you may have a logo or branding that you want to protect. The most important thing is to make sure that the co-founders, as employees. They've assigned all of their intellectual property to the company. And any employees that you bring on, have also signed an employee mention assignment agreement so that the company owns everything. And investors will very much care about that. When they come in, and I'll get into this a little bit of diligence, when they come in, they will do their legal diligence on the company. And they'll want to see that anyone who's creating intellectual property for the company has executed an agreement like that. Talked about proprietary information invention assignments. That's exactly the document that does it. Make sure everything's owned by the company.
You know, you had one from if the intellectual property, originally the portion of it is owned by the university. There could be in many of these cases.
Right.
How would that be, dealt with?
Yeah, so typically it is owned by the university and licensed to the company. And it may be in the form of exclusive license, it may not be, but it's typically licensed. It's probably speak more about this than I, or speak to this, but the company will have the rights to this intellectual property. And let's just say it's a license or exclusive license, then it will owe, there'll be probably commercialization milestones, and it'll ultimately owe, royalty back to the university once it starts commercializing. But so in that scenario, you're right that the base IP or the core IP may actually be owned by the university, but it will have licensed it to the company.
So maybe they will address later on. Can you sub-license? You've taken the license from the university.
Yeah.
And as you're running through, you want to really have other organizations develop it.
Yeah.
Can you sub-license?
Probably yes. It'll depend on the license that the university grants to you. But I think generally, the university is interested in getting tech out of it to a company that's going to go and commercialize it and do something. So I think generally, again, depends on what the license terms say, but yes, you often do see that the company can then go sub-license it to continue development. So this next portion is related to what we just talked about in terms of things to think about when you set up your entity, because these are questions that are going to be asked and looked into when you go and actually raise money. So, what will investors expect you to have in place? They will expect you to have an entity that they're used to seeing, generally a C corp. They will expect to see that all of the issuances, equity issuances have been documented. They'll expect to see that all, intellectual property that's being created is owned by the company or is licensed to the company. And, basically making sure your legal house is in order. The last thing, Ashok can speak to this, and I'm sure he's been talking to you about, why do investors invest in, companies, and why do investors invest in teams? And a lot of it's for non-legal reasons. Most of it's for non-legal reasons. They believe in the founders. They like the business plan, the product. But one way to quickly get an investor to say no is to show them a messy legal structure. Just that'll scare off an investor very quickly. You have an entity, but you've got a very messy cap table or an incomplete cap table. That raises red flags in any investor's mind that, well, if they're messy about this, what else am I missing? And maybe there's just somewhere else we should go. So make sure your legal house is in order. That's what we've been talking about. Be prepared for diligence. Be prepared to answer the questions that hopefully you have the answers to, because you've been thoughtful about your equity. You've been thoughtful about making sure that everything, all IP is owned by the company. And then, obviously there's going to be, be ready to negotiate with the investor for how your company is going to change when they invest. Like I said, it's always evolving. So board composition may change. They're probably going to want a board seat, depending on what size of check they're writing. They're obviously going to own a large portion of equity, or the right to own a large portion of equity at an early stage. They're probably investing at a low valuation. So how much equity are you willing to give up for that? What controls are you willing to give up? So those will all be part of the negotiations with the investor at the term sheet stage. Is the company really investor ready? What gets an investor to know quickly? Like I said, it's kind of them walking into and seeing a mess, or just, unorganized, documents, things that, they get in and they're like, well, here's 5 things that, you would immediately need to go and clean up. That's an easy way to get them to know, because there's a lot of opportunities out there. And, so you want to be prepared. Just briefly on diligence, again, high rate of failure in startups. And, there are not many unicorns, a lot of failures or modest returns. So, why do they want to invest, or more importantly, why would they not invest? Like I said, a lot of that has to do with non-legal things, about your technology, about your business plan, about the founder's ability to execute. But a quick way to get to know is to have a, messy structure from a legal standpoint. So legal diligence is important, and it will be important as they start looking at your company. It is time consuming. You're trying to run a company and build a product, and also while going through, a financing that requires your attention to answer, diligence questions that they have. You're probably gonna have a small team. You're gonna be probably the person or one of the few people who can answer these questions. So, expect to spend, a good portion of your time working with the investor or their team to answer questions and get them comfortable, with what they're asking. Let's see. Yeah, let's go on to the raise. So, this is, you're looking at, a seed round. Maybe you bootstrapped it for a little bit, or you've kind of self-funded, but now you're going out and you're going to bring in some outside capital. And what should you be thinking about? Obviously, thinking about how much, and having well thought out answers to how much do I need to raise and why. Tying it to your business plan, tying it to your uses. They will care very much that you're not just out there raising $5 million because it feels right, and that's what you want to go raise. Every investor is not it's not equal. Cash is not always equal. You got to think about the things that different investors may bring to you, vis-a-vis their networks or experience, in addition to their cash. Would they be a good board member? Think about it as a partnership and a long-term partnership, because once you raise money from an investor and they come onto your board, you're not going to easily get rid of them, and you're going to have to deal with them. So if they're willing to write a check, and that's great, but you are going to have to spend a lot of time with that person. And if there's not a fit, try to identify that early, and think about whether you really want to be in business with that person. So just briefly on securities laws. So when you are selling equity in your company, or you are selling securities, so you are subject to U.S. securities laws. And generally, what that means is you want to sell to what's called an accredited investor. It's just a person that is basically thought to be able to fend for themselves because they make a certain amount of money. They have a certain net worth. The things you don't want to do are go out and just do a general solicitation of, hey, I'm raising money. Do you want to invest in my company? Don't want to go to a room full of people when you're pitching and say, offer to sell, securities in your company. You want to be going to, targeted, VCs, angels that are known, angel networks, upon going through that process, Houston Angel Network, for example, talking to a group like Goose Capital that that you're talking to all accredited investors. Stay, compliant with securities laws. We get questions all the time about, can I go, can I give my cousin wants to invest $25,000 in my company, something like that. Well, is your cousin an accredited investor? Well, what's an accredited investor? Okay, well, does he make more than $200,000 a year? Or with his spouse make more than $300,000 a year? No. Does he have over $1 million net worth, excluding his primary residence? No. He has a lawn business or something like that. So he's not an accredited investor. There are ways for non-accredited investors to invest, but the rule of thumb, and I think just the thing to generally try to stick to is you want to sell to accredited investors. You're gonna wanna get a certification from them, basically checking a box that says, I qualify as accredited. Your attorney can help you with that, but just be thinking about that when you raise money. You really should just raise from accredited investors. Let's see, so term sheets. So I think the high level things to think about when you are negotiating a term sheet are the economics of the investment and control. And those are really the two things that you're thinking about in terms of when you're taking money from an investor. The economics are, how much of the company are you willing to sell? What are the terms of that investment? And then, control. How much control are you willing to cede to that investor? They're going to take a board seat, okay? Are they going to have certain veto rights as a board member, certain actions where you need their vote saying yes to do certain things? Those are the two kind of high level concepts to keep in mind as you're negotiating with investors.
If you have already an investor, then you're going after raising some more. Now, these people, based on what you have put down, will have an equal amount of sale, right amount of sale. How do they bring the other taxes? That kind of thing.
They probably will. So if you have raised a round and you're going to raise another round, you'll probably have your early investors that will have a say in terms of the next investment, what they're willing to do vis-a-vis their existing investment. Do they want to keep their seat on the board, or are they willing to step off because the new investor wants to see? So yes, depending on the terms, but typically if you've raised a price round, the first investor in will have some sort of consent right to you doing the second round. Okay, so just on the types of investments. So you could sell equity in your company. That's called a price round, where you have established a valuation of the company that the investor is willing to invest in the company, and that establishes the price per share that the investor will pay to get equity in your company. Or you can do a convertible instrument, which would be a convertible note, or what's called a SAFE, simple agreement for future equity. We'll talk a little bit about each of those. Let me just touch briefly on. So we talked about economics and control. So control are things like, again, board seats, observer rights, voting and approval rights. There will be kind of major decision type things that the investor will have to approve, regardless of whether they're in the minority, which they will be, but they'll have to approve certain things. And that's fairly typical for a price round, that you're going to give up some amount of control, at least as to bigger, major decisions like that. You'll have information and reporting requirements. Investors will want periodic financial statements delivered to them. I mean, certainly annual, quarterly as well, and sometimes even monthly. Some investors will have kind of nuanced things. They'll want you to maybe develop some sort of key performance indicators, maybe, and report to them and have discussions with them on a pretty frequent basis, just so that they're very up to speed and kind of hands-on about what's happening with their investment. So there'll be that. You'll have information on reporting obligations, and then sometimes they'll have requirements for management. They'll want to this kind of ties back to what we talked about when you set up your entity in terms of vesting. So let's say that as co-founders, you have, gone ahead and subjected your equity to vesting, and 2 years down the road, an investor comes in and says, we're gonna invest in your company, but we want you to revest. And so you've earned 50% of your equity, let's say. The investor comes in and says, we want you to revest a portion of your equity. We want to see you have more skin in the game. And so sometimes, and this is always negotiated, because founders will push back and say, no, we've been working on this for 2 years. We've earned our equity to date. If you want us to have, if you want to give us some more equity, subject that to new vesting, we can do that. So that's always a negotiation, but the idea is they want to see you revest, let's say 75% of your equity, and it basically takes you back down to, okay, 25% vested, and then you've got to start, you vest the remainder of the 75%. And the idea is just always, investors always want to see that a founder has skin in the game and is earning the equity. They want that founder or those employees, they want them working in the company and driving value to the company. One way to do that is to incentivize them to earn their equity. So the term sheet will specify the securities, whether you're doing outright equity, which would typically be a preferred class of stock. So we talked at the beginning about the founders and employees, they get common stock in the company. Investors don't buy common stock. They don't buy the same class of stock. They buy what's called preferred stock. And it comes along with usually a liquidation preference. We get paid if there's a sale event or a dissolution, investors get paid out first on their preferred stock, and then common gets paid out after. So you could have a preferred stock, but you could also do convertible instruments, which, like I said, are convertible notes or SAPEs. The reason for doing convertible instruments is it's always hard to pinpoint a valuation, or sometimes hard to pinpoint a valuation on a company, right? Especially in an early stage company. And even when you do, it's not a science, it's kind of an art. What feels right to the investor and ultimately what gets negotiated. But if it's so early that there's just no way for anybody to really, know what the valuation should be, or it's just not worth the time to try to figure it out, you'll probably end up going with a convertible instrument that just says, okay, we're going to invest, and at some point in the future, upon some event, this is going to turn into equity in the company. The one way to do that is a convertible note. It's debt, so it's got an interest amount, bears interest. It's debt on your balance sheet, and it does, it is a debt-like obligation, so there's a maturity date. Investors probably like convertible notes more than safes, just for that reason. They can kind of compel something to happen if you haven't converted them by the time the maturity date comes along. Typically what happens is they'll extend it, but maybe for an increase in the interest on the note or some other concession. Ultimately, VCs and angels aren't looking to be repaid their note. They're looking to get converted to equity at some point and get that upside that they think, you're going to be able to create. So they're usually willing to work with you on that, but it's something to be thoughtful about as a founder, that if you issue convertible notes, it's debt. And at some point, those are going to come due.
So this is very much like you're taking a loan from them. You're paying an interest on it.
That's right.
And they have the option to either convert it into equity or just say, give me my money back.
They do have that option. If it hasn't converted, we'll talk. So let me answer your question, but also talk a little bit about one of the main features of the note. The main feature of the note, the main idea is that when the company does an equity financing, and it's usually what's called a qualified equity financing, like you've raised $1 million, that'll be in the note. But when that happens, when the company does that, the note automatically converts. The note holder, the investor doesn't get to say no. They automatically convert. The problem comes up when you issue notes and things don't happen the way you thought they would, and you haven't raised that equity finance, and the note comes due. Then technically, yes, the note holder is going to be to do the thing. They know that the company doesn't have the cash to do that, and they're generally not expecting that to happen. They usually genuinely want to see the company get to a point where they raise enough money, they convert to equity, and they get to take their upside, because they are VCs and angel investors. They're not banks. they're not just looking for that interest, they're looking for the upside by investing in their startup. So, but point is, yes, it is debt. Yes, they are credited and they have unsecured creditor rights, so they can demand payment. Versus a safe, let's see, simple agreement for future equity. This is the same thing that it is an instrument, it's a convertible instrument that upon some future event, it's gonna convert to equity. But it's not debt, it doesn't bear interest, there's no maturity date, it's just a contractual right, future equity. And so from a company standpoint, you don't have a creditor sitting there saying, time to repay me, or give me this if you want me to extend my maturity date on my note. You just have this safe sitting there and it sits there until you do something. So safes are more company friendly from that standpoint, plus investor friendly. Investors don't have a hammer to hold over your head saying you need to do something. They just sit there until they convert on the terms. And there's and most, I would say most, or many angel investors are comfortable with safes. They're more common on the West Coast and some on the East Coast. I think you'll find in Houston, some resistance to them, as opposed to out on the West Coast. They came out of Y Combinator, which is a famous incubator on the West Coast. And the idea was it's in the name, they're supposed to be very simple, quick way for a company to get money in the door without having to negotiate a bunch with investors and getting lawyers involved.
Now, I know in all of this, you never think about taking a loan from a bank. But if you took a loan from a bank, how would that, translate? Is it just a straight loan?
Yeah.
And then you have terms to pay back, or?
So if you were able to get a loan, I mean, typically you're not, the reason you're taking this very expensive capital from VC and angels is they're not bankable. There's no bank that's gonna give you a loan because, you don't have any assets they could foreclose on. You're not generating revenue or certainly no profit. So,
And even your personal guarantee wouldn't be
Yeah.
worth a lot.
Like a development bank, export-import banks.
That's different. They're not like a regular bank.
Yeah, they're not
They're
regular.
meant to invest,
They are
but that's
doing-
only in countries that have private-public partnerships, unlike the United States where that doesn't really exist. That's why what Lee's talking about is your only avenue.
Not very much here. Understand.
So you have your convertible notes and your safes, and typically the common theme among those is it's hard to figure out what the valuation is. So we'll just set what's called the valuation cap. And we'll just say that, the company and the investor will agree that $10 million sounds about right, or $5 million, or whatever it is. And when that convertible instrument converts, that cap will be what's used to calculate the share price that the investor will get when it converts. So it protects the investor from the sense of, if I do, for example, a $10 million cap on a safe, and the company does really well, and in 2 years goes and raises around that $20 million valuation. I, as the early investor, should get some benefit from having taken that early risk and gotten you to that point. It's $10 million cap protects me in that I'm not going to be paying for new equity in the company at a $20 million price. I'm going to get the benefit of my $10 million price. So again, safes are not notes. They're not a debt obligation. They're more company friendly. They're viewed as a low cost, simple option to get capital. And most investors are. So I think this is where Greg steps in. So again, I covered a lot, tried to keep it at a high level. I think there is more detail in the slides. But if you have questions, certainly reach out. I hope this was helpful.
Thank you. Hey, great. Thank you, Lee. I think we've got a couple slides to go before we get to you, or are we right up? Okay, types of intellectual property. So we now know how important it is to have great corporate structure, governance. I do want to make one comment about stock options. All the companies I ran, every employee had options, down to the secretaries and Not a lot. But the excitement of when we went public, that everybody in the company was gonna make a little bit or a lot of money was palpable. So I would think of, and typically what we do, particularly when we do the investments, we set aside between 10 and 20% of the total shares equity or stock options. So you could have 10 million shares in the company, 8 million of which are owned by founders and investors, and 2 million shares that are set aside for stock options or hiring a CTO or a CFO, people, qualified people you want to bring on board, or even a CEO if you're all techies and you want to bring on a business partner. So having said that, over to you, Greg, for IP.
Thank you.
And thank you, Lee. That was great.
Well, thanks for having me. I appreciate being here on Saturday morning to talk about IP, which I've been doing for about 30 years. So mostly in the patent field, but we also do some trademarks, copyrights, and that sort of thing. So we're going to touch on all sorts of IP today, but the main focus will be patents and to some extent trade secrets, because those seem to be the most important for a technology company type of startup. So that's been focused most of our time on. Patents, as you probably know, cover processes, compositions, machines, that sort of thing. Proprietary equipment is, I think of it as a sort of a form of a trade secret. That might be equipment that you use internally for manufacturing that you've developed yourself. It's not just purchased off the shelf and you make a decision that you're going to keep this proprietary and secret to the company because it gives us some sort of manufacturing advantage. So that's another type of IP. The third one on the list is trade secrets. That again can be just about anything that's of commercial value because you keep it secret. So that could be customer lists, that could be the way you go about your pricing. On the technology side, that could be compositions, that new drugs, new different types of formulations that you decide to keep trade secret as opposed to going for a patent. And the reason you might keep something as a trade secret is because those can last forever. As long as you keep those secret, those can last forever. Whereas a patent, that lasts for 20 years from the date you file. So with the idea that in exchange for making your invention, talking to the public about it, putting it in a patent, the government will give you the exclusive right to exclude others for that 20 years. So it's kind of a contract with the government in exchange for disclosing what your invention is as opposed to keeping it as a trade secret. You get that exclusivity period. The fourth one on the list is copyrights. That's more for the expression of the idea. You think about photos, motion pictures, books. On the technology side, software code can be the subject of copyrights. But primarily, we're talking about the expression of the idea. And it could be cartoon characters and things. If you're doing computer programs, it could be some of the icons and things that you use. Maybe the screen or the look and feel of the user interface could be the stuff copyrights. Yes, sir.
What about podcasts and ebooks?
That could be stuff with copyrights.
Really?
Yep, certainly. The copyright registration process is pretty simple. I have a presentation that I give to clients to help them do it on their own. It's $50 or $60, and it has a drop-down menu, very simple to do. You don't need to be paying a lawyer or paralegal to do copyrights. Maybe the first one, maybe you need some help, but after that, you can do your ebooks and things on your own with the Copyright Office.
And what about YouTube, publishing of content, video, lectures, stuff like that?
Certainly, when you put it on YouTube,
Yeah.
you own the copyright. You, of course, can register it at the Copyright Office if you choose to. And YouTube has a takedown policy where if you have registered it at the Copyright Office, it makes it much easier if somebody's pirating it to get YouTube to take it down. So it's a good thing to think about for a professor like yourself.
Yeah.
And then the last one on the list is trademarks. That covers your branding, the outward facing of your logos, your marketing, and that sort of thing. And those two can last forever as long as you're using it and you're filing the proper renewals at the trademark office. And in terms of startups, I don't think of those as important as the patents and the trade secrets. So that's kind of the pyramid of what we think of as the most important components for a startup, with patents at the base, because that's the technological component. And on patents, you can have both utility patents and design patents. And what we think of mostly for patents is utility patents. That's the stuff, the compositions, the processes, the technology that goes into an invention. The design side of things, you might see in footwear, it covers the ornamental features of a product of some sort. So Nike, Adidas cover some of the ways that their shoe is designed. You might see it in furniture design. You might see it in lamps, some things like that. Ceiling fans, we see some of that. So those are the two types of patents.
Remember my window washing, skyscraper climbing? The shape of the suction cups is a design patent, and the rest is a utility patent. So they're two separate ones. So as you said, but it's very technical, because that shape of the suction cup re-engineers Bernoulli's principle, as we talked about. So just to put it in perspective, the way he's designed the airflow around the suction cup is the design patent, and the way he runs it is the utility patent.
No, that's a great point. Oftentimes there's overlap, and as an IP attorney, my job is to help the company develop picket fences. So we're choosing the right place to use the trade secrets, the right place to use proprietary equipment, the right place to be using patents, and the proper time for doing that. So we can marry basically the business strategy to the IP strategy and make sure that we're putting as many barriers in place for competitors as we can as we go along. And so there is that overlap between some things you decide to keep as a trade secret, other things you might decide to patent. You might have a manufacturing, a specific way of manufacturing your product that's patented. Maybe you keep that specific way that gives you higher throughput, or it's easier to do, less equipment. Maybe you keep that as the trade secret, but you get a patent on the product. So you can stop anybody from using any process, but you think you have the best process. And so as far as patents go, there's basically three requirements to obtain a patent, and they are novelty, non-obviousness, and utility. Utility is basically the easiest one to meet. It just means that it has some useful function in industry. And so that's usually not very difficult to meet. Novelty is probably the second easiest one to meet. That just means you have some minor feature, some feature, whatever it may be, that's different than what's been done before. The fight that we normally have in getting patent is the non-obvious aspect. And that's the subject of most of the fights. The timing and disclosure is crucial for a startup. I think, normally we recommend you get the lawyers involved as early as possible. Not so much because you want to file immediately. Maybe you do, maybe you don't. But when you have a lawyer involved that can look at the prior art and help you as you're doing your design process, we can look and see, what have other people done? Are there blocking patents that we maybe need to get around at the outset before you're too far into the design process, where you've expended a lot of resources already, and you've got a final product, and you look and you find a patent, oh, that's going to be difficult. Now we have to redesign our product. But the other reason to get involved early is maybe it is a first to file system. So if you have competitors working in the same spot, same space, the first one to get their patent into the patent office will be entitled to the patent. So that's another reason to look at the timing. the provisional versus full patents. We have, and most countries have provisional patent applications. Those are applications that are kept in secret. They're not examined. They're much cheaper as far as the filing fees. The only requirement for a provisional application is that it teaches somebody how to make and use the invention. And so it may be just a PowerPoint presentation that we end up filing as a provisional patent application because you're going off to give a presentation or something, and we want to make sure we get something into the patent office to put the stake in the ground that here's our idea, we've already developed this, and here's what we have right now. And the provisional application will give you up to 1 year to kind of further refine, work on your invention before you have to file the full application.
When do you get in the line in being that you are the first to do this? Is it provisional or is it real?
The provisional application, to the extent it actually does teach enough information. And so, like I said, sometimes there's emergency situations where we run in, file the PowerPoint presentation before the professor's about to give his talk at a conference. But, oftentimes we put more thought into it and kind of think ahead. Here's the research plan that we're going to do over the course of the next year. Here's what we expect will happen, and make some predictions in the provisional application as to where we might be in a year. And as you have technological breakthroughs, over the course of the year, we might even file another provisional to describe, that unexpected breakthrough that you had. And again, that's to try and get ahead of other people as they're working on the same thing.
Yeah, that's how Edison beat Tesla
Hmm.
to the electric production of electricity. He was the first to the patent office.
Wow.
One of the most famous stories.
And so that's basically want to get the lawyers involved early. I realize there's limited money in a startup, but we're used to working with startups, and we're accustomed to that. But we really want to be involved in the business strategy and the IP strategy to make sure that they sync up. I know there was a question earlier about the university IP and tech transfer. So the universities typically own the IP that's developed by their employees, which would be the professor, but also by anybody that's using institutional resources. And I think U of H is like that. Is that right, Mike? And typically most universities will have a period of time that if you think you have something that's inventive, there's a requirement to disclose it to the university within a certain time frame, which U of H is at 3 months. 3 months before most universities want you to disclose it before you go make it public, so the university can make an informed decision about whether they want to file a patent application. And then once that happens, if the university decides they don't want to file a patent application, oftentimes the IP will revert to the inventor at that point. The university decides they want to go forward and try and commercialize it, then that will be the time when there's some negotiations as to a license. Is that fair, Mike?
Yeah, we have an intellectual property committee that's required by our Board of Regents. And after that IPC gets involved in the decision to convert from provisional to non-provisional, which is some months after the original invention disclosure. But the invention disclosure by a faculty member does not guarantee that there'll be a provisional filing. So there's two hurdles.
Okay. And so is it the case that if there's not a provisional filing, then the professor or the PhD student can do what they want?
That's right.
At that point?
You waive the right.
So, it's important.
Does that happen often, Mike?
It's a good question. The challenge we face is most faculty don't disclose, and they're more interested in publishing and winning awards than disclosing their inventions. So we're trying to train them on changing their behavior. The fact of the matter is faculty are like human beings. Sometimes I wonder if they are, but I'm one of them. they do what they're rewarded for, and intellectual property is not rewarded, part of the reward equation, and we're trying to change that at the academic level.
Yeah, I think most university professors think of it as I'm contributing to the greater good. Everybody should
Right.
participate in this invention.
Remember my Ashokism, education requires sharing knowledge, entrepreneurship requires protecting it. Paradox.
It's true.
And so licensing terms, and this may be with the university, these may be with a commercial partner of the startup, or another company. But licensing can take many forms. It basically, however, the two parties decide is best to commercialize it, and that will benefit the parties to the best extent. So it might take the form of an upfront royalty of some sort with an ongoing royalty, or it could just be a paid up royalty. I'm just gonna buy your invention outright. There could be equity involved where, as Lee said, the startup gives some sort of ownership interest in the entity. As the slide says, that helps to align the incentives between the licensor and the licensee. As far as the royalties go, it could be percentages of profits, it could be percentages of sales. Sometimes it might take the form of it's an exclusive license if you're meeting the minimum requirement of the sales, but if you don't meet the minimum, then the licensor can go out and find other licensees. Or sub-license, the licensee might be able to do some sub-licensing as well. So there's basically not many restrictions on the terms that are licensed. As far as the kind of contracts and agreements that hit on IP that you might see as a startup, NDAs, that stands for non-disclosure agreements. Those are basically confidentiality agreements, and those can be unilateral, meaning that if I have confidential information and I want to work with a contractor, I'm sharing that with the contractor. They can use my information only in their work for me, and they have to keep it confidential. Or if it's kind of a joint venture type back and forth of some sort, some joint work, it might it might be mutual non-disclosure agreement, meaning that each side has confidential information that they want the other to protect in doing the work. The other agreement you might see is sponsored research agreements, and that's where you're paying someone, and sometimes it's a university, oftentimes it's a university, to do research on the technology, and typically in exchange, the researcher will transfer the IP rights to the contractor. But not in all cases. Some cases we see these sponsored research agreements come out of licenses with the university, potentially, where the university owns the IP, but they want the professor or the PhD students to develop it, so they give them a license to the entity, but then the entity in turn has to hire the university to do some sponsored research as part of that license. So it returns, instead of equity, maybe it's sponsored research or equity plus sponsored research exchange for license.
Question.
Yeah.
What are your thoughts on when the government like DOE or any large federal institution provides funding to the university for founders to go research and file patents? And then also, what about stuff like NASA, tech transfer? NASA makes available their IP portfolio to go commercialize. What are your thoughts on that, and where does that fit? Where do we need a lawyer there?
Yeah. Typically, it'd be helpful when you're taking the grant to look at the terms of the grant and decide whether you really need that money that badly that you're interested in giving the government a license back on the terms that the government demands. And it's a complex question because it There's the small business innovation, which has different terms than the DOE grants in some cases. So it really depends on the granting agency and the terms. So it's useful to get somebody involved. And it doesn't have to be a lawyer, but somebody that does these types of grants and knows what you can have the government agree to, so you get the most favorable terms for the grant. But typically, the government will have a free license back, maybe with some restrictions, but that's a great question. Does that answer it?
It helps. What about the NASA tech transfer? They say there's 100 portfolio, go build something on it, and then NASA will give you permission for a year to use that IP, and then
Yeah, I think that's mostly coming from the SBIR grants, where the small business will actually own the IP. And NASA will have certain rights to it as long as you're following the rules of the SBIR. There's certain disclosures at certain times you have to make when you make a technological advancement. There's certain reports you have to file on an annual or quarterly basis. And so it's important that you understand, that the entity understand those and making those reports, or you will forfeit some of your rights. So there's always strings attached when you're taking the grants.
That's why I said to you, Colin, check to see if you can get Nigerian government grants for what you're doing.
Might be more favorable than the US grants. So from an investor perspective, we talked a little bit about the diligence that goes into it. As far as IP diligence, many times the potential investor will be looking at your IP assignments to make sure those are all in line. They'll be looking at all the contracts, especially with any independent contractors or consultants you've used, to make sure that they're required, they have an IP assignment. You know, oftentimes you get to a point where a company wants to sell off or merge with somebody, and they go into the diligence and they've got an independent contractor agreement that doesn't have an IP assignment, meaning that the independent contractor, to the extent that they develop some IP, they have ownership rights in it. And then we're in the position of having to negotiate with the independent contractor to get the rights before we do the deal. So that's always a good thing to kind of get those things buttoned up before any diligence. And of course, they're looking for regulatory issues. They're basically looking for any types of red flags. They're looking that the technology has been proven, the business plan is sound, that sort of thing. The other thing they're looking for is a freedom to operate. And what that means, what a freedom to operate is you're an entity, you have your own technology, but is that going to infringe on somebody else's technology? You know, you might have a patent and it might be directed to a way of using a screw in a certain machine. But if somebody's got a patent that says it's a machine with any type of fastener, then that's going to be broader than what you have, and you're going to need a license from those folks. And so, you know, what investors will often be asking for is, did you do a freedom to operate analysis? And so it's good to have that in your pocket before you start taking on investors or talking to investors, because they will ask that question. And like I said, oftentimes we want to do some sort of analysis even in the early design part of the project, so that we can make sure if there are barriers, we can move around them and explain to the investors how we've moved around those barriers. So unclear IP ownership. Obviously, if there's pending litigation, that's going to be scary to an investor. But a freedom to operate analysis will mitigate that. Because they're also nervous about, hey, what happens when you do launch the product? If there is something out there, get an immediate lawsuit, injunction, shuts the company down after they've made this investment. So fundraising and IP, clean chain of title, Lee talked about the convertible notes and the simple agreements, and board control. International issues. We talked a little bit about the US provisional applications and the regular applications, but there are also something called PCT applications. That stands for Patent Cooperation Treaty. And there's also European protection, which can come off the PCT application that we'll talk about. And there's also export control, which is regulatory issues. And the data protection and HIPAA is also a concern to investors. And it's not just in the US, that's international as well. If you're operating internationally, the privacy issues are becoming more and more important and more complex. And investors want to make sure that you navigate those. So PCT applications, it's administered by the World Intellectual Property Organization. It's been around since I've been practicing law, which is 30 years. So it's been around way before that. It's not so much an international patent, but it's an opportunity to basically plant your international flag, and it gives you, the most important thing it does is gives you time to decide where you want to file internationally. And so it delays by 30 months from the original filing date, the decisions that you have to make and where you want to file, because it's not a trivial decision about where you want to file, because it's a big investment to file in Japan or Korea or Europe, because there's translation costs involved. You need to hire an agent in each of those countries. There's filing fees. There's also annuities that are paid every year in most jurisdictions to the patent offices. So it gives you time, which you need as a startup. That 30 months is really important.
When you get this 30-month period, let us say you file just about the end of the 30-month period. Does your priority goes back to the very first day, 30 months before?
Great question. Exactly. That's part of the treaty, is that all the countries have signed on that you can get priority all the way back to your US provisional application. So the typical route for our US-based clients would be to file a provisional in the US, within the year, file the US and the PCT, or sometimes we just file PCT only with the idea we can always file the US at that 30-month date. And that will
PCT
defer.
is absolutely the most valuable tool in your toolkit.
PCT?
Yeah, it delays costs, which is huge. And there's some other benefits too. It's like I said, it's not an international patent, so it's not something you can enforce against anybody or sue anybody for infringing your PCT. You get those rights once you filed in the country of interest. But it does provide a number of benefits, including, yes.
So I have a question regarding, let's say, the research has been done in the United States and we have filed the patent, but it has been sponsored by the government itself. So as if government holds some right in the patent, and as an international student like me, if I want to go back to my home country and practice that patent and make something out of it, so are there any legal constraints that to be aware of?
So just so I understand, so you filed a US application at this point, the government has some rights to it, and you're interested in going back in a different country and practicing the invention. Do you control the rights to file in the other country, or does the government control those?
I'm not sure.
Yeah, you have to
Well, you
look
gotta
at,
find that out in a hurry.
yeah.
Or is it the university?
So typically the university, I'm talking about the PhD research. So as if we
Okay.
file, but the research has been sponsored by the government itself. So university is the owner, but government has certain rights in that patent, right? So let's say I move out the country and go back to my home country and I want to practice that
But
patent.
what are those certain rights? That's too nebulous. What are those certain, you said the government, is it NASA you're talking about?
Not the United States government.
Commerce Department gave you a
80
grant.
Brazilian people, who? In the US.
DOD or BOD or?
My research,
Or
no, my research has been sponsored by NSF.
Oh, National Science Fund.
What rights do they have?
I'm not very certain about like what rights, but,
Yeah, so quite possibly, under a lot of these grants, it would be, you have to inform them which countries you're going into at the appropriate time. And if you decide not to go into a certain country, they have the right to go into the country and they'll own all the ownership, they'll own all the rights in that particular country.
And what if
But
it,
I think, but if
I
they
think
not
we're
file a
creating
patent
like-
in that country, then there's no rights in that country. Typically, they only file it in the US, most of the patents, even. So if you go to a country without, production in that country, then you can do,
Yeah, if there's no patent in a country, anybody can practice whatever they like.
most of the cases,
Well,
that's the case.
what if the patent belongs to NASA? What would be done?
If it belongs to
NASA.
NASA.
You're the one that has the
Yeah.
NASA
Yeah.
technology.
Yeah, and you have a license with NASA.
We applied for the testing and validation license, actually, but we still are in the process of getting the exclusivity rights.
Okay, so that'll be part of the exclusive license agreement as to, who can file where and what happens if you decide not to help pay for it, then they're gonna probably insist on they have the right to pay for a patent in a given country and commercialize it with some other partner. You might just have exclusivity for, whichever part you negotiate.
Do you have a lawyer helping you? You should get one. I mean, if the future for this invention is big, how you, remember one of my slides from the very start? Build that moat. And your legal strategy becomes more important than your technology strategy.
Ultimately, though, in a case like this, getting back to what you were saying, if the university is not filed in a certain country, then all bets are off. But if it has, then there are certain limitations that the inventor has in that particular country because the university owns the IP.
So we'll get to how you, there's a whole other section I think Greg will talk about is how do you get the technology of the university into your own company? That depends on people like Mike's department trying to make it easier. So as you know, from my last 7, 8 lectures, I do not think universities do a good job helping their students. Some do, MIT, Stanford, Northwestern, but in general, students, what was my line? University tech transfer is a cork in the ass of progress.
What did you say?
No, and U of H is really making an effort to join the team, like helping transfer, or like all across Europe. I mean, it's astonishing how good these universities are in allowing their R&D projects to spin out as companies. Germany is the model.
Yeah, I mean, the university agreements that I've seen will be an exclusive license to the entity to commercialize it. But the entity pays for the patents, makes the initial decision about where to pursue those patents. If there's a particular country that the entity decides not to pursue, they decide they're not interested in Europe, then the university might have the option to, the university pays for a European and they'll go find a European partner if they believe in technology.
Most universities are not capable of that. They really are not commercially focused. They don't. So that's not so much the problem as much as someone else doing it from under your nose. Reverse engineering it or doing it. So that's why getting the PCT on file is so important. It gives you 30 months of protection.
What's the cost range for a PTC in the US?
Basically,
PCT is in Geneva.
but you can file in.
You can file anywhere,
You
but
can file in each individual patent office, but their headquarters is based in Switzerland. So kind of
About $5,000 US.
yeah, 4 to 5,000. Yeah, for a small entity startup, you think in terms of about 3,000.
it's mostly legal fees.
That was the filing fees, but the legal fees, if you've already got your US patent application prepared, oftentimes it's just using that same application and paying the filing fees.
How much
So
is the filing fees just?
the $3,000 to $5,000.
Yeah, I'm saying that the.
And then the legal
major
fees on top of that.
component Patent strategy is legal fees, is what the
It's
lawyers
con-
charge.
Yeah, so to prepare the US patent application, assuming a full-blown patent application, $8,000 to $10,000 at ballpark. You know, certainly if it's very complex, it can go up to $20,000. But at that ballpark, at 8,000 to 10,000 in legal fees, and to file the US, it's a provisional is $150 filing fee. A full-blown application is around $800.
And there are, not to undermine Hunt and Andrews Kurth, there are firms in Silicon Valley, legal firms, that will take on legal work for startups and take some of their fee in options. That's not commonplace in Houston, but on the West Coast it is, and in Boston.
I remember those TV ads where the little invent, we'll do it for you
Don't use those.
and. Good.
Get
Good
what you
advice.
Pay for on those. Silicon Valley's a better option with a patent lawyer as opposed to an AI generated
absolutely.
application. So,
No, but then I think these guys will also work with you.
yeah, we do to some extent. We have discount fees and things that we're used to working with startups, and, frankly, we like to grow along with the startup and hope they all mature into a big company and we're doing their employment work and everything else, but.
And I understand there is a group, is it TELA, something, Texas Attorneys for something Arts? It's an association that offers free services, initially.
I'm not
Are you aware?
familiar with them, but the USPTO website has, there are some agents, patent agents, which aren't lawyers, but they're trained patent practitioners that can write and draft patent applications that do some pro bono type work. So that's a resource also. I don't think our local IP association has any, the Houston Intellectual Property Law doesn't have anything like that that
Now,
I'm aware
your
of.
best bet if you want to cut corners is ChatGPT, but that's, like you said, you get what you pay for.
Yeah, I mean, we're normally working on an hourly basis, and so is every other law firm in Houston. But the more stuff you can bring to bear on it initially, as opposed to, I got an idea and here's 3 bullet points, the less expensive it will be to go through the drafting process. The more work that you can do on your own, as far as research and that sort of thing, it will reduce costs.
To put it in perspective, U of H has about 700 patents,
Wow.
both US and foreign, and we pay about 12 law firms to write the applications. They're approved by the State Attorney General's office. So of the 700, maybe 40 or 50 are actually producing income in terms of licenses to the university. We had one patent that went commercial called VimPat that was bringing in about $70 million a year for several years, and that's gone off patent. That's unusual. That's a home run in the university patent business. Most patents never have a license. So that's the challenge our office has, is identifying the patents that have commercial value.
And most of the time, Mike, it's a very good point, Mike. Most of the time, the fact that it might have value is based on the team that decides to commercialize. Because some of them may have a lot of value, but nobody knows what to do with it because nobody's sort of engaged with the invention.
I think
So it goes back to the university trying to then marry the researchers, maybe business people, like the Lightrotech example I keep bringing up, right? The 3 genius engineers. They didn't know what to do with it, so they went out and got themselves a real good, powerful business guy to run the company, and now they're home run.
tagline to what he was saying, that the university faces, which hopefully Mike will bring up later on. There is a cost of maintaining all these patents. And if they
Yeah,
don't produce
right,
any
talk about
revenue, 1 or 2 unicorn probably are producing a lot of it to cover. It runs out sometime and you still have to maintain the others.
That's
That's
exactly
his job.
right. In the US, there's maintenance fees that are due at 4.5 years, 7.5, and 11.5 years. And for the most part, 75% don't even pay the first maintenance fee on their patents
And it lapses.
and it lapses. Just because they're not commercializing it or technology has moved on. You know, some of these fast moving technologies, you know, filing for a year or two or three and that's it. It's moved on.
Mhm.
And the cost of those go up over time with the idea that if you're still using it after 11 and a half years, the government's going to charge you more because it's beneficial to you. So I think it goes from about $2,000 to $4,000 to about $8,000 over the life of the patent. But if you've got patents in other countries, you've got annuities due in every year almost. In most countries, annuities get paid every year.
Yeah, for instance, when we talk about those 9 steps to your business plan, remember the 9 components? One of them is use of funds, the ask and the use of funds. I want to raise $5 million and I'm going to use it this, this, and this. As an investor, if I don't see something that says maintaining or IP, then I'm nervous. There's always, you need some of that use of funds for filing and maintaining patents.
Right. And the freedom to operate, which is so
Yes.
important.
Right.
So time was one benefit of the PCT, gives you that 30-month runway to make decisions and commercialize it. But the other benefit is sort of the procedural aspect of the PCT, because once you file it, if you file at the USPTO and ask, you can decide what country you want to do the search. So you can file in the US and say, hey, I want to pay Europe to do the search for me and do the examination. Most of our US clients, they'll file at the USPTO and have the US do the search. And after the search, they come out with a written opinion. And that's basically, hey, we've looked at the prior art. We've decided that initially our preliminary view is some claims have novelty, they're inventive, other claims may not, or they say all the claims are inventive. And so that gives you some preliminary idea of, hey, am I going to be able to actually take this through the procedure and obtain a patent when I do go into the individual countries? So that's of some benefit also. It will also give you an idea, if you hadn't done your patent search at that point in time, it will give you an idea of what's out there as far as potential roadblocks on the freedom to operate side. So you get not only the benefit of time, but the benefit of an actual examiner looking at this and giving you their preliminary opinion so you can make good investment decisions going forward. I've already talked about what the PCT is, the main benefit. It streamlines the filing process. Instead of having to go into each individual country at the outset, you can file the PCT and it's as if you had filed in all those countries originally, or at least the countries that you decide you want to chase down later on. And it's been pretty steady since there's not been a lot of changes to the PCT process and the application and the law and the treaty. It's been basically the same since I've been doing this for 30 years. So, you know, that's a benefit. The other benefit, it's more recent. They have something called the patent prosecution highway, which are in some cases like bilateral agreements between certain countries that they will, once you have the PCT, if you have a favorable report from the PCT examiner and you decide to go into Japan, then the Japanese examiner will give some deference, and that's why they call it the patent prosecution highway, put your application at the front of the line and approve it more quickly because they're deferring to what the PCT office already found that's patentable. So that can save some time and save some costs as well to go that route. They're not obligated to do that, and it depends on the country how much deference that they do give to that PCT report. In my experience, Canada is very deferential to what the US does. China, not so much. They just make it very difficult. So part of that may be political, but that's been the trend. In Europe also, Europe is just not very deferential to the US, what the US does. Even though you have an allowed US patent, the European patent examiner is going to do their own search. They're going to come up with their own findings, and you may well end up with the same thing, but they're going to put you through the paces.
So do you know, out of all the countries that have signed the pact, who's submitting the most patents? And any stats on that, or this year, next year? Like,
As far as which countries?
yeah, or
Yeah.
where are the inventors coming from?
Yeah, there are statistics on that. I think WIPO, the organization, publishes those. I'm not sure on an annual, but biannual basis. And there's also the Intellectual Property Owners Association publishes statistics. That's IPO. They come out every year with a list of not only which Fortune 500 companies have filed the most patents, but patents by country of origin as well of the inventors. But I think China has by far the most filings based on individual vendors. So the PCT basically is the time extension. It also publishes after 18 months, which could be a good thing or a bad thing. The good thing is it might keep away competitors a little bit if they think there might be a patent that's coming out of this, because at that point it's just uncertain whether there will be a patent issue. But certainly if you have a favorable report or semi-favorable report, competitors might see that, think, well, maybe we might want to go in a different direction. Of course, you know, if you decide if it's an unfavorable report and you want to keep it as a trade secret as opposed to having it published for the world to see, you can withdraw it a couple months before that 18-month date. So it's a conscious decision that should be made with the lawyers involved to decide, hey, maybe this is better kept as a trade secret at this
For
point.
example,
Publish it.
Coca-Cola's formula for 100 years. They've never patented it.
You know, when you keep it as a trade secret, if others come up with process which are overlapping or very close, they are not bound to be not practicing it. They can just practice.
That's it. That's the risk of keeping something as a trade secret. Somebody might independently develop it. I think a larger risk is that one of your employees runs off, regardless of your confidentiality agreements, takes it to a competitor, and all of a sudden your competitor has a product and you don't know whether it's ripped off or not ripped off. So that's one of the risks of trade secrets. You can keep it forever, but if you can keep it secret.
Like Coca-Cola.
So the PCT has a lot of benefits. It's definitely worthwhile and keep it in your toolbox as a startup, and as Ashok says, keeping budget for that. At the end of the 30 months, you need to select your countries if you decide you want to pursue it in the individual countries. And that, as a startup, you have to be judicious in which country you select, because it's very, very expensive. This last statistic I saw, to maintain a patent in the Asian countries of interest, in Europe and the US, could be $250,000 over the life of the patent, which is over 20 years. That includes all the annuities and everything else. So it's not an inexpensive thing to do. So oftentimes we counsel folks to look at, where do you think your biggest market is going to be for the product, and look at those markets as to where you want to be. Also where you manufacture would be important to have a patent where you're manufacturing it. And thirdly, where your competitors might manufacture it as well. One thing to think about though is if you do have a US patent and you're concerned about somebody manufacturing it in China and bringing it to the US, a US patent will protect you, because
In the US. Only.
with the US patent, you can stop people from making it, using it, selling it. So if somebody's importing it to sell it, then they're infringing
You
your
can't
US
stop them
patent.
from making it, right? Because they'll continue to make it
That's
in
true.
China.
You can
But they
stop
can't
them
bring
from-
it in here because you'll sue them. And there's one or two things that could happen. You could get damages if they have money, or you could stop them from doing it.
Right, and we'll talk about the International Trade Commission and help with that. So this lists, some of the IP protection agencies in the US. Sorry. You have the USPTO, that's for the patents, and they do trademarks as well. You have the Copyright Office, which handles the copyright registrations. The ITC is the International Trade Commission. That's who you can go to if you have a problem with somebody abroad infringing your products and bringing them into the US. You can file what's called a Section 337 action with the ITC. It's basically a patent infringement action. Moves much faster than if you would sue them in district court and have to hassle with serving them abroad and all that stuff. And you can get an injunction. The ITC will issue a stop order, which you could then take to the US Customs and Border Patrol, which is the next agency, and have them stop the product from coming into the country. In my experience, you can't just give them the order and expect they're going to inspect every crate that's coming in to make sure it doesn't have infringing products. You're going to have them. You know, if you have a private investigator or somebody that can figure out which boat it's going to be on, and so they know what to look for, as opposed to just giving them the order. So it's not a cheap and easy thing to have happen.
Here's a question I get asked a lot, Craig. And is filing for a patent in China of any value, or will that still allow them to reverse engineer it and do it and bring it in, and we have to spend on private investigators on determining the quote? Would it be more helpful to just file a patent in China? Will they respect it? Can you sue them there?
It's changing. 30 years ago, when I started, I'd say, don't waste your money. They've only had patent protection for 40 years or 50 years in China, but it's rapidly evolving. It's changing. I think if you're looking at it as a short-term thing, maybe it's not worth the spend as a startup. If you're more interested in the long term, I would say it's a value. You know, it used to be U.S. companies didn't have any success in enforcing their patents in China, except against other U.S. companies. But now there's been some success, and it is cheaper than a U.S. lawsuit. There's no discovery. So you have, to stop somebody from infringing, you've got to know what they're doing. So if it's a manufacturing process, you're going to have to know exactly how they're manufacturing, which is the difficult part about discovery, to see what they're doing in the factory. But I'd say as a long-term prospect, if you're looking ahead 20 years, it's certainly worthwhile. Do other people give you a different answer?
No, yours is probably the most definitive so far. Most people really,
Lawyers say,
Yeah.
it depends.
it depends, yeah, it depends. And this was specifically as it related to our window washing robot, skyscraper climbing. And most of the advice has been, don't bother. If they want to reverse engineer it, they'll do it anyway.
Yeah, I mean, I do think you have to have boots on the ground to find out who's doing it. And then the last agency, the Department of Justice, they pursue theft of trade secrets. Their focus is mainly on foreign actors right now. The statute, it's the Economic Espionage Act. They can go after domestic entities, domestic thieves of trade secrets as well, but focus mainly has been on actors taking U.S. trade secrets and going to places like China and taking. And we've had a couple instances where we've had civil lawsuits and we have the Department of Justice involved. I would say, don't invite the government into your life unless you really think you need them, because a lot of times we can solve it on the civil side of things much better than the government telling you, we're going to come in, look at your computers, talk to your employees. It's a big business disruption, even bigger than a civil lawsuit. You invite the government to. Okay, so IP protection worldwide, those are some of the agencies, the WIPO and the WTO. Europeans have their own agencies. that are listed in the slides, which are the EPO and the national IP offices. So even once you get an EPO patent, oftentimes you need to decide, do you want, which individual countries do you want? Because those are an additional cost where you want to validate, unless you go for one of the newer unitary patents. And so we talked before that just because you have a patent doesn't mean you can practice it. If somebody has something that's broader on the freedom to operate side, same thing is true on the regulatory side. You can get a patent, doesn't mean you can practice it. Oftentimes you need approval from FDA, EPA, or some of these other organizations, depending on the technology. So,
Okay, thank you. That was pretty useful, I think. I just put these case studies up as to where IP protection worked and where it didn't. You know, that resolution, I once again said these were this was a finalist in this year's Rice Business Plan competition. Check them out. Have really complex, very sophisticated technology coming out of the university, being spun out of the university, along with government grants. And they're a freestanding company now with a full license from the university that they own. And the way they went about protecting it with several patents and trade secrets is a good success story. You know, everybody knows about Genentech, and of course, you all talked to Lydrotech, how they went about it. Again, similar to Resolution, they got a German government grant while they were doing their PhDs. The university, the university was very helpful to them in putting together a non-draconian, non-punitive license agreement in perpetuity so that they could spin out the technology and create a company. And as I said, they're off to the races right now. And here's an example of somebody whose technology IP strategy was a complete failure. We don't have too much time to go into them, but I think Theranos for more than just the IP strategy is a good case study for you to look at. It's also about founders, a founder getting carried away with themselves and lying. Remember one of my Ashokisms, the last one that I presented on the first lecture? If it feels wrong, it is.
Too good to be true.
So if you can stick with that, you will not have sleepless nights about SEC violations or IRS problems or licensing breaches, all that. Just do the right thing. So the key challenges and pitfalls, as we've talked about, first on the legal side is complex ownership. If you've got lots of founders, I think that's always a problem. One of the things I think Lee did not talk about, at least I may not have been paying attention, is to have an inter-founder agreement. Did he talk about that? No. Where all the founders sign an agreement that gives them the right to get back the stock from a founder that is leaving, if it's leaving, if he or she's leaving in hostile circumstances. You don't want your stock being owned by an outside party that's hostile to you. So you should have the right of first refusal to purchase their stock back. The company should, at least. So that's a very important. So, and then consult a good lawyer and get a good intra-founder agreement that allows you to buy the back stock, that has certain rights on voting and all of that.
and a non-compete too.
And a non-compete, exactly. Yes, thank you. So and I can see most of the teams here are multi-founder, except for Colin. You're a single founder. You don't have any of these issues. And so to recap, we've said this several times, but your intellectual property is your secret sauce. It's your long-term competitive advantage. And it's what investors will really scrutinize. So make sure you know what it is. By the way, Greg, to be able to, for you, let's say you were being asked to file a patent with them, what do you need? How much and what do you need?
Typically, a good disclosure of what you believe the invention is. What are the key process steps? If it's a process, if it's a machine, what are the key components? How do they work together? you know, if it's a machine, diagrams are easy, sketches work well. Process though, we need steps, what's the temperatures, degrees, what the reasonable range of things that work, the chemical process, what are the catalysts, what else might work, just some thoughtfulness about.
Pages of information. Are we talking about half a paragraph or 20 pages?
No, the more information, the better,
Mhm.
but bullet points will work as a starting point, because as a lawyer, our job is to ask the right questions to give the right information.
So the more detail, let me give you my perspective, the more detail you can provide up front, the less it's gonna cost you. Because the questions they ask also cost you, because they're billing you by the hour. So the more detail you can go, the more research you can do on your own part, not about your research project, the research on what does a patent application look like, and all that is available. So put in the work instead of them putting in the work. Let them do what they're good at versus what you shouldn't be paying them for. Particularly a startup when funds are tight. And so, closing, IP, like I said, is your secret sauce, your most valuable. And the stronger your IP, the better the valuation you're gonna get from investors. And you should be telling a story with what your technology is all about, what your IP is about. So the competitive moat you're built around your secret sauce. That's what today's been all about, and that's why I'll give you a couple of lessons. When we think about Houston as a city, Houston became the energy capital of the world, not just because of all of the innovation they had, like, George Mitchell's horizontal drilling or fracking or all of that. It is because they created great legal structures. Master service agreements, joint venture agreements, risk-sharing partners. So really, Houston becoming the fourth largest city in the country and the energy capital of the world. I hate to say this, but lawyers deserve credit.
You know, Ashok,
It always hurts me to say lawyers deserve credit, but I have to say it.
just read an article about Houston that, and the headline was the worst designed city in the world.
Those are politicians,
Yeah.
not the lawyers.
Well, it's a different subject, but
Yes.
no zoning.
Yes, those are the politicians. No zoning. Yes, totally. Yeah, you can have a school next to a church, next to a brothel, next to a factory. So, yeah. That's why some of these communities like the Memorial Villages or River Oaks have, have tight zoning carved into Houston. So this is the lesson of the city of Houston. We started off with like a little cowboy town in a swampland. And the real city of Texas at the time was which? Bingo, Galveston, wealthiest city in the country at the time. Because it was the big port. It was even a more important port than New Orleans. And then we took over because we did all of this, and the lawyers get credit. So the 5-step checklist, make sure that the IP from the university is assigned to the company in some tight fashion, whether it be a perpetuity license or whether it be an outright purchase. But if it's shaky, where the university has all sorts of rights, then you're going to have trouble in the future because, they're also greedy. If they see all of a sudden you're very successful, they'll come back at you if you don't have anything tightly locked up way up front. Already said, fire early, file provisionals, get good contracts, clean chain of title to your IP. Again, talking about the transfer or what you invent on your own or what you're getting from NASA, getting from NSF. And make sure you've also got your international bases covered with the PCT. And then let's go back to the example of the window cleaning robot. We have filed patents. We have PCTs for the various 6 or 7 of them, the different process and utility patents, but we've got patents filed in India, filed in Singapore, in the Middle East. There is a Middle East consortium where you don't have to file by country, except Saudi might be a little different. They may need their own. The United States, France, Germany, and Japan. Typically places where you have a lot of skyscrapers, where you want to be protected from somebody reverse engineering what you do. So, to recap, we've said this, and Greg and Lee have both said this, so I don't need to read from the slide. Make sure you've got solid IP base. Licensing must be clean. And all investors, regulators will scrutinize your IP strategy before they make a move, either in terms of giving you money or giving you approvals to operate. Okay? And as usual, we have after class assignments. But before we get to that Q&A, do you have questions of Greg and Lee, even though Lee had to leave? Any questions? You might have something relating to NASA specific, you're gonna, this is $1,200 an hour free advice. You're not gonna get it.
Hours, by the way. He's also here for 2 hours now.
And Lee as well, so I'm saying, this
Oh, my
is
goodness.
great free advice. You step out of the room, you're gonna have to pay for it.
So they
Let's
meant-
keep him in the room.
Cup of coffee.
I have a question, yeah.
Yes,
What are the major risks for filing with NASA patents?
Sorry, I didn't.
What are the most common risks on filing NASA patents?
Well, I think if it has to do, if you're taking money from the government, it's the provisions that go along with taking money from the government. So the devil will be in the details of your license agreement and whatever contracts you have so far.
do you have a license agreement with NASA?
At the first, we had the license agreement for research and validation, validation, and the other one that we filed recently is the testing and validation process, which is, we're waiting for that one.
But that you filed as a
When
company,
we file,
but who owns the core technology?
NASA.
So you contracted with the lawyer to do the application, or did NASA?
Well, because we have people who are helping us from NASA also as well, so.
Yeah.
But not with the lawyer.
Yeah, I would just be careful, because they might not have your best interest in mind as they're developing the
Yeah,
application and contracts.
And what if the technology or the patent is pending? Isn't that different process or?
You can continue to develop the technology, I would say, as you get to something that you would consider a breakthrough or something that significantly advances it, then, you revisit whether to file an additional patent application.
The fee charges that you were mentioning earlier, that also applies for like a NASA application fee, sorry.
There's two different aspects to the fees. One is the filing fees that the government charges. So those are for a provisional application for small entities, about $150, $200. For a regular utility application that will be examined, it's about $800. And then the separate fees are the preparation fees and the time that the attorneys spend in assisting you in writing the application. And as we mentioned, I think we both mentioned that the more you can do on your own, the less expensive that.
Okay.
I mean, and also Kumi.
Yeah, Kumi.
Yeah, I mean, this lecture is probably the most important lecture for the two carbon capture teams in Kumi.
Yes, I agree.
And they're both there. All three of them are not here. Anyway, their loss.
We'll get them the recording.
I hope they will.
What my thought on an assignment for you all, how many of you intend to file patents for your filing course? Yeah. Assignment for next year, the next lecture is please do this, what Greg outlined, the 1 or 2 page description of what your patent. This will get you thinking about what you will eventually have to do. Just a 1-pager on what your patent application is gonna look like. Describe the process, describe the design, whatever it is your patent is. And if you've got multiple patentable designs and utilities, pick one that's most important. force yourself to do this homework. I know I can't force you, but it'll help you. Certainly, if Fumi and the two carbon capture teams, you're the power supply team, right?
No,
No.
medical.
Medical, you're the med tech team. And the power supply team too.
Yeah,
How
power
about that?
supply team is very important.
Wow. The foremost, the people could have used Greg's input the most. Let's make sure they at least get the chance to see this. Because, as I've said, the reason Houston is what it is today is because of the legal strategy used by the lawyers of Houston to protect everything we do here and make us the energy capital of the world. So that should be the assignment. Hopefully, you all intend to do it. Thanks. Yeah, so answer, I've already given you an outline of what your roadmap should describe, what IP is relevant to your venture, who owns the IP, what entity do you plan to form and why? C Corp, LLC, LP, subchapter S, what do you want to call? And what risks do you foresee? So there's two elements to this. One is the legal structure part, which was Lee's, and one is the IP part, which is Greg's. Likely to do a write-up on if you have the time and the inclination. And here's some reading that'll help you. I always try to pick out good stuff. I don't know how many of you get around to reading some of the recommended reading.